Can summary judgment be based on circumstantial evidence? Have you ever wondered how courts decide cases without a full trial? In the realm of elder law and estate law, particularly during will contests, this question becomes quite relevant. Summary judgment is a legal tool that allows a court to resolve a case when there is no genuine dispute about any material fact. This means if one party is entitled to judgment as a matter of law, the court can make a decision without going through a lengthy trial. Now, let's talk about what material facts are. These are the facts that really matter to the outcome of the case. If there is no disagreement on these facts, the court can step in and decide the case. But what about circumstantial evidence? This type of evidence does not directly prove a fact but allows for reasonable inferences to be drawn. It becomes particularly interesting in summary judgment motions. So, can circumstantial evidence be used for summary judgment? Yes, it can. The key factor is whether this evidence creates a genuine dispute about a material fact. If the circumstantial evidence supports one side's position clearly, it can lead to summary judgment. However, if it allows for multiple reasonable interpretations, it may prevent the court from granting that judgment. In the context of will contests, summary judgment can play a significant role. For instance, if someone contests a will claiming undue influence, circumstantial evidence might include the behavior of the alleged influencer or financial transactions that raise questions. If this evidence does not create a genuine dispute about whether undue influence occurred, the court might find it appropriate to grant summary judgment. When considering summary judgment based on circumstantial evidence, courts must evaluate all permissible inferences in favor of the non-moving party. This means the evidence must be viewed in the light most favorable to the opposing party. If the circumstantial evidence allows for reasonable interpretations that support the opposing claims, summary judgment should not be granted. Attorneys involved in these cases must carefully analyze the evidence. They need to think about how a jury might interpret it. If there are multiple plausible interpretations, it is likely that the case will proceed to trial instead of being resolved through summary judgment. Understanding these dynamics is essential for anyone navigating the probate process and will validation.